interpretations as well.
So the second item is that the new additional or altered use is a use subject to approval of a site plan. I don't think that that's, I'm sorry, the altered use is a use subject to the approval of a site plan when it was not required for the preceding use. That is true. A change in any feature of existing site development that is subject to approval under a site plan when the change is substantive, resulting in expansion or an increase in site development or intensity of use, such as a change in grading patterns, increased area covered by parking, loading or paving, increased traffic generation, modified access and traffic patterns, and changes in the location of site improvements, including landscaping, signs, and lighting, and any change in use or site development that would modify the statement of use. There never was a statement of use, the site plan, the architectural plans, or any prior conditions. So under that definition, this does meet that criteria. It is properly in front of the planning board, in my opinion, and any building permits that have been granted or anything else that relates to improvements on the site is not a matter that this board really has any say over. That's a building department matter. So I just want to mention that for the record. I had a couple comments. The Philipstown Town Board is getting ready to enact stormwater management laws. I expect that they'll be enacted in the next 45 days. That's on your agenda tonight, to review those proposed draft laws. And I do not believe that this action will be approved with building permits in that time frame. Under that proposed code, if you do not have a building permit, you are subject to the law, which requires the submission of a stormwater pollution prevention plan. So that is something that I would recommend be included in the application and submitted sometime before this public hearing closes. A landscape plan should be submitted that shows landscape improvements and lighting. As Bibbo and the board have suggested, a traffic study should be prepared that looks at the AM, PM, and Saturday peak hours for the subject property. It includes movements at all access points and at the Route 403, Route 9 intersection. And I think the traffic study should probably look at whether or not it does make any sense for there to be restrictions on any turning movements at any of the locations of access out there, given its proximity to the intersection of Route 403 and Route 9. At the end of the day, the DOT grants permits and they dictate what takes place on the state highway, but this does involve a seeker review. You will be lead agency on this action, and the DOT will take those matters into consideration in their permitting. And I would recommend that the board immediately draft a letter to the DOT stating that this is under their review and requesting that they not issue any final work permit until such time as the board has completed its review and a traffic study. It would just be a lot easier for the DOT to work with the town prior to having written any work permits than after they've issued a work permit. I think that this northbound lane should be reviewed for a potential turning lane, left turning lane into the subject site. I would recommend that a Phase 1 site assessment be prepared and submitted if it hasn't already been done so. These are standard reports that are done when property is being transferred. They're done according to an ASTM standard. Banks use them as a means of ascertaining if a site is clean. An ASTM report should reveal the entire history of tanks, tank registration, tank pools, remediation, any consent orders where monitoring was required, etc., and that should be in the record for this application. Any existing work permits from the DOT should be provided to the planning board, and then we would not have any further comments. We don't know if variances are going to be granted or not for this application, so if they're not in the way that they've been requested, the site plan could change, and I would keep this public hearing open until such time as those variances are granted and you know that this is, in fact, is the plan that will be acted upon. And then finally, I believe that this board should declare its intent tonight to be lead agency pursuant to seeker and should conduct a coordinated review and circulate the long-form EAF to the DOT, the DEC, the county health, and the county planning department, and the zoning board to conduct a coordinated seeker review. Because there are other agencies and other actions that will be required for this application. We want to make sure that when a decision is made, that it is upheld and not subject to a mistake. So.
Tim, I just have one other thing I wonder if you would just go over for the benefit of everybody present tonight. And that's that this is essentially a pre-existing, non-conforming lot. It exists as that. The gas station has existed for many years. And could you maybe just go over how that right remains, that the owner still has the right to use it, even though it would never get site plan approval today?
Well, it would if it were a non-conforming lot.
Right.
And that's what makes it non-conforming. This is in a B2 zoning district. In the B2 zoning district, a lot needs to be 40,000 square feet minimum size. This lot is about 0.6 acres, so under no condition would it conform. Generally, the criteria for granting approvals on a non-conforming lot is that if you conform to all aspects of zoning, you are allowed the permitted use. And in this case, I'm not sure it's entirely known what prior bulk conditions existed on the site, because there is a certificate of occupancy that was issued in 1981, I believe. It's in the building department files, and it does indicate that this use was there prior to zoning, but I don't believe that there's enough dimensional information on that certificate of occupancy to say this is what the pre-existing non-conforming setback was for the various structures on the property and so on and so forth. So the applicant is in front of the zoning board in order to legally be able to proceed with bulk variances where setbacks from side yards, etc., may in fact not comply. Is that correct? Correct. Does that answer that question? Okay.
When we finish, you will provide us with a list of the items. I've tried to copy as many as I could down.
I have a memo.
Okay, good.